doctrine known as diversion of corporate opportunity. It's the notion that a fiduciary, an officer or director, who learns about a business opportunity while serving as an officer or director, at least in some circumstances, has an obligation to disclose it to the corporation and allow the corporation to take advantage of it before they take advantage of it. It's a very important doctrine, very important, because of course, fiduciaries of a corporation encounter business opportunities all the time. And the core of the duty of loyalty is that directors and officers owe a duty to promote the interests of the corporation over their personal interests. And you don't want officers or directors to use their position to find good business opportunities and then take them for their own benefit. So the core notion is one of the oldest notions in corporate law. The question is how to articulate the duty and how to articulate the standard that determines whether an officer or director has breached it. The traditional case law, the case law in Delaware and many other states, has a multi-factor analysis that looks at a variety of factors, some of which have to do with how you learned about the business opportunity. The principles of corporate governance, one of their big innovations was to rethink the doctrine of diversion of corporate opportunity and said we need to break up the question into two questions. One question is, was this a corporate opportunity? Was this a business opportunity that, properly speaking, belonged to the corporation? A kind of property, if you will, intangible property, but a kind of property. Once you've defined that, the principle said, then we have to answer the question, did the fiduciary take corporate property in a proper way or an improper way? We know from other sections that there are times you can take property from the corporation if you pay for it, if you enter into a transaction that's been approved by disinterested directors and so forth. Perfectly fine. Two separate questions. Was it a corporate opportunity, a quasi-property notion? Was it taken properly or improperly? We follow the principles, which have been adopted in 4 or 5 states over the last 30 years, because we think it's a better rule. We think that it provides guidance both to judges as well as to directors and officers and lawyers as to first whether something is a corporate opportunity or not. And then secondly, if it is a corporate opportunity, whether you've taken it properly. As it happens, even the Delaware people recognize that the Delaware test is not a very helpful test. It's a bunch of factors to consider. It works, I think, extremely well in the hands of Delaware judges who are experienced, who have a sense of what's proper, what's improper, who can find their way through. The test provides sort of an ultimate framework for them to do the equitable kind of the equitable interpretation that they do. But for a judge outside of Delaware who doesn't have that sophistication, it isn't helpful. It's not that it's misleading, it's just not helpful, as these multi-factor unweighted tests often are unhelpful. That's led to a great deal of unpredictability, and in response to that, there have been legislative developments that allow corporations to renounce corporate opportunities in advance. These were driven by firms that wanted to hire directors who said, I'm not going to come on the board because I'm a director of these other corporations, I'm a CEO of this corporation. I can't shut down my business to serve on your board. So unless you can give me comfort that I won't be violating my fiduciary duties when I go about my normal business, I can't come on your board, And companies that want to be able to retain such directors, appoint such directors, went to state legislatures and said, we need to be able to give people comfort. And so most states have adopted a version of a statute that says that a corporation may in advance renounce certain categories of corporate opportunities. And that has helped, but that's an indication of how problematic the traditional rule has been. That if the traditional rule had been more clearly defined as to what was a corporate opportunity and what was not a corporate opportunity, then this pressure would not have emerged. The principles the part of the principles we're restating, I think, has a narrower view and would have made the renouncement of statutory provisions unnecessary. We include the renouncement provisions because they're prevailing law, but I think if our view, the principles view and the restatement view of corporate opportunities is accepted by courts around the country, then corporations will not feel the need to renounce, which would be good because the renouncements can go too far. So we define for an outside director, we limit what is a corporate opportunity to business opportunities that the outside director becomes aware of during his or her service as an outside director. So if you're sitting in the boardroom and somebody comes in and says, I've got this business idea, I'm developing this product, are you guys interested? You don't want a director going out and saying, well, I'll buy it from my other company. You want that to be the corporation's opportunity. On the other hand, we all think that if the outside director learns about it in his other job, that shouldn't be a corporate opportunity. And under the restatement definition, that would not be a corporate opportunity. That would not be a corporate opportunity. What counts as a corporate opportunity for outside directors is sharply limited, as I think is appropriate, as I think in practice the Delaware rule as applied did, but the Delaware rule was so unpredictable in its formulation that there was pressure from the VC community to change the law, which Delaware did. So I think it's a significant move forward. I'm hopeful that ultimately Delaware will accept this and adopt it in their law, but I'm not targeting Delaware. They're doing just fine. But I think many other states that don't yet follow what was originally the principles approach will find it useful because it solves a lot of the most difficult problems of unpredictability that arise out of the traditional test.